This webinar on employment law focuses on sexual harassment in the workplace, presented by Kara Brzezinski. The Manitoba Human Rights Code protects Manitobans from discrimination and harassment in employment. This applies to both paid work and volunteer work for workers who are provincially regulated. For those workers who are regulated by industries like banking, transportation, telecommunications, they'll likely be governed by the Canadian Human Rights Act. Complaints about human rights violations can either be made to the Manitoba Human Rights Commission or to your individual workplace. There are laws to protect against sexual harassment at work. The Manitoba Human Rights Code makes it illegal for unwanted sexual advances at work, especially if the person has power over you. It's also illegal for reprisals, where an employer makes threatened or actual negative consequences for rejecting a sexual advance or for trying to enforce your rights. Our current laws quite clearly say that sexual harassment can be equated with discrimination on the basis of sex. Unfortunately, until 1989, when the Supreme Court of Canada released its ruling confirming this, it wasn't always the case. A few years prior, in Jansen and Platty Enterprises, a Manitoba Court of Appeal judge stated, and I quote, "I'm amazed to think that sexual harassment has been equated with discrimination on the basis of sex." Section 9 of Manitoba's Human Rights Code lists numerous characteristics that are protected against discrimination and harassment in employment. We now know that this clearly includes sex that can be interpreted as sexual harassment. Employers must take steps to prevent harassment and discrimination when they know or reasonably ought to know that something's occurring. They have to investigate complaints, and they have to do this quickly. The Workplace Safety and Health Act requires that all workplaces have a harassment policy, and employers have to take action swiftly if harassment is occurring. It's also illegal to do anything of negative consequence for somebody who has reported, experienced, or who is trying to enforce rights. Manitoba's Workplace Safety and Health Act, Part 10 of the regulations, sets out detailed requirements that ensure harassment policies are in place for every workplace in Manitoba. On this screen and the next screen, you'll see some of the legal requirements that must be contained in every harassment policy. Of course, simply having these statements in a policy is not going to meet the legal requirements. What's most important is that this policy is looked at, reviewed, that people are trained on how to deal with harassment and how to make a complaint, and then it's updated to reflect the current situation. Reprisals, unfortunately, are far too common when employees try and exercise their legal rights. It is against the law for retaliatory actions to be taken against employees in either exercising their legal rights or mentioning those. It's important to be aware of what this could look like. It's often when somebody is removed from a regular group or meeting, when hours of work or work location, reporting supervisor, or duties are changed. Discipline, particularly where this discipline is discriminatory in the sense that other workers doing similar actions are not being disciplined. And termination. We'll walk through a few case examples of actual decisions that have been made in Manitoba and in Canada dealing with sexual harassment at the workplace. A young worker had been subject to repeated offensive comments and jokes. At first, this employee didn't report the jokes because she was worried she would lose her job, as it was the business owner that was making these offensive jokes toward her. For example, The owner suggested that one of the UPS drivers wanted to sleep with her. He would point to the underwear section of the catalogs and say that that should be her new uniform. And he would make some offhanded remarks about screwing in order to remove wood casings on some shipments. The complainant didn't report the jokes because she was uncomfortable and she was worried that she would lose her job. She was worried she would be retaliated against. The Human Rights Commission held that this in fact was sexual harassment, and unfortunately so. It is not required that a complainant has to actually object to the acts of harassment at the time they occur. The test is whether a reasonable person in the same position would realize that these actions were unwelcome. It was a customer this time that was making sexual comments about an employee's body. The customer would repeatedly come in and make several comments and even rubbed his lower body against the employee with physical contact. The employee asked the business owner to stop this. The business owner spoke to the customer, but the harassment continued. When an employer allows sexual harassment to happen in the workplace, even if the harassment doesn't come from a fellow employer or fellow staff, the employer is still responsible. This is important because owners may be slow to respond as they don't want to lose customers, but they are still responsible and liable for the working environment of their business. In this case from British Columbia, a server at a nightclub was required, along with the other female employees, to wear a bikini top at a themed work event, instead of just a t-shirt. The male bartenders and door staff were not required to wear anything gender-specific or sexual. The complainant was uncomfortable with this and instead wore clothing on top of her bikini and complained to her union and employer. As a result of that, she was disciplined, assigned to a different position at the club, and her hours were then reduced. These actions were found to be discriminatory, where employees of one identity, such as gender, are expected to meet more difficult requirements than employees of another identity, or are expected to dress in a sexualized way. This may be against the law. A correctional officer was subjected to harassment at his workplace. The harassment was based on his sexual orientation, as well as his status as an Indigenous man. Some behavior included unwanted sexual jokes and gestures, name-calling based on sexual orientation, unwanted sexual advances, and unfortunately, a sexual assault. Sometimes the employee participated in the jokes at his own expense as he wanted to fit in. The employee repeatedly reported the incidents, though not formally at first. He was reluctant to share the names of the people who had been harassing him for fear of reprisal and retaliation, but he was very clear about the incidents that occurred and the impact that it had on him. A very brief workplace investigation was conducted, but determined that without names, it could not proceed, and it found that no proof of harassment had occurred and closed the file. It was found that in fact this was harassment, and it was the largest award in Manitoba history at $75,000 in damages, plus other compensation. Note that Manitoba currently has a cap of $25,000 on damages. Harassment and discrimination can occur on the basis of multiple protected characteristics at the same time, and it was found that he was being harassed and discriminated on the basis of sexual orientation, race and ethnic background, and facing unwanted and offensive sexual advances, so it was a combination of factors. It's important to highlight that participation in the jokes does not cancel out harassment. People can participate in jokes out of fear or wanting to fit in, but the adjudicator was clear that this does not justify or minimize the harassment experienced by coworkers. It was further held that workplaces have a duty to fully investigate any reports of harassment. A workplace that does not adequately address or investigate harassment is liable. Even reports that may be anonymous, workplaces must still do something. If you've experienced sexual harassment at work, you can either contact your employer or file a complaint with Human Rights Commission. If it's serious, you can also contact the police. You have to make a complaint within 1 year for the Human Rights Commission. You can also contact the Community Legal Education Association by calling them or by looking at information available online.